Thank you guys very much for coming. I want to just thank ACS for holding this breakout session, and also for all the panelists for agreeing to come, some of whom flew across the country for the panel. And I want to especially thank Kara Stein for getting all those ducks in a row to think through what we're going to talk about and hopefully present something cogent and interesting to you. So before we start, some administrative points. One is on cell phones. We are recording the session, so if you could silence your phones or turn them off, that would be helpful. Twitter. If you want to tweet about the session or anything else that happens during the convention, I just wanted to remind you that ACS's handle is @ACSLaw, and the convention's official hashtag is hashtag ACS2017. And I would direct you to the Twitter handles of our panelists, but I don't think any of them have them according to our bios.
I have like one follower, so that's
yeah. So I'm @Tom Javits, which is easy enough, but my name is hard to spell, but it's up there. So CLE credits, if you want to or you need to get CLE credits, just make sure you sign in with the staff outside the room. I think right now, before the panel starts, is that right? I think you got to sign up, so sign up. And then as far as just the run of show, like what we're going to do, so the panel runs from 11:15 till 12:45. I'm going to do a brief introduction, then I'm going to pose a few questions to the panelists to generate a conversation. I'm very much hoping that people don't just wait for me to ask them follow-up questions, but you guys should just talk because it's a lively group. And we're going to leave a good amount of time for questions. If you have questions, you should feel free, one, to use the mic right there. We are recording it, so you want to make sure the audio is captured. And two, feel free to ask questions on things that are not directly related to what we've actually talked about on the panel, because there's so much happening in the immigration refugee space that there's no way we're going to cover everything or even touch on everything. So if you have an area of particular interest, go for it. So my name is Tom Javits. I'm the head of immigration policy at the Center for American Progress. Before that, I spent some time with the Immigration Subcommittee for the House Judiciary Committee, and before that, I litigated immigration detention conditions cases, deaths in custody, medical care in custody, with the ACLU National Prison Project. To the far side is Jenny, I wrote it down. To the far side is Jenny Chang Newell. Jenny is a senior staff attorney with the ACLU Immigrant Rights Project. She has worked on numerous and varied cases over the years to protect constitutional rights for immigrants with respect to due process and judicial review. She's also challenged some anti-immigrant state laws and policies, and that's something that certainly we're going to see more of, I think. We sort of had put that to rest for a while. There was a trend against that for a bit, and now with a new law signed by Texas recently, we may see a renewal of that. To her right is Leon Fresco. Leon is a partner at the law firm Holland & Knight. Before he returned to private practice, Leon was the Deputy Assistant Attorney General for the Office of Immigration Litigation at the Department of Justice, and before that, he was the staff director for the Immigration Subcommittee under Chuck Schumer in the Senate. He was the creative and colorful person at the center of S-744, which was the comprehensive immigration reform bill that passed the Senate in 2013 with 68 votes. To his right is Jennifer Chacon, a professor of law at the UC Irvine School of Law, where she explores issues at the intersection of immigration law and criminal law. It's what us immigration nerds call crim immigration, or crim-im. And then to her right is the Honorable Dana Lee Marks, who has for the last 30 years been an immigration judge in the San Francisco Immigration Court, and for nearly half that time has been the president of the National Association of Immigration Judges, which is the union that represents the Immigration Judge Corps. So the topic of the breakout session today is a nation of immigrants no more, question mark. Right? It's a great question, I think, to kick off a discussion that is going to talk about a lot of different topics, because I think it gets to the core of who we are as a nation and who we are as a people. It is part of our national sense of self that we are a nation of immigrants, e pluribus unum, right, out of many one. But while that principle has long been part of our national sense, it's been ingrained in us as kids, the nation's history with immigration actually has been quite complicated and quite uneasy. Right? So from the Chinese Exclusion Act of 1882, attacks on Italian and Irish immigrants in the 18th century or 19th century through the early 20th century, Japanese internment and the internment of American citizens of Japanese descent, and the rejection of Jewish refugees, including children, in the run-up to World War II and the Holocaust. Each time, fear has been the greatest force, sort of the central force, challenging our national sense of welcome. And fear continues to play an important role in the immigration refugee space today. So you see that in the demand to build that wall, right? Those three powerful words that carried through the campaign. Despite the fact that we have net negative migration with Mexico at our southern border, and we have historically low border apprehensions, not just in the few months that the administration has been in power, but over the last decade, we continue to be at 40-year lows, essentially, with border apprehensions, and yet nevertheless there's a narrative that runs through the country that the border is out of control. You see it in the president's call for a total and complete shutdown of Muslims entering the United States during the campaign, which is a policy that he has now twice tried to put in place through the Muslim ban, and that even though that ban has now been rejected by the courts twice, and we're going to see where that all plays out in the coming months, I would think. In fact, actually, the ban has in some ways, at least partially, taken effect. We just got data recently showing that visas issued to nationals from Muslim-majority countries are down 20% this year over last year, and for nationals from the 6 countries named in the second Muslim ban, down by 55%. At this point now, I don't think we can possibly disaggregate whether that's because petitions are down from nationals of those countries, or if acceptances or grants of visa petitions from nationals of those countries are down. But again, whether it's because people are walking themselves out or coming to the US, or we are closing our doors to them, the effect is really the same. And then you see in the efforts to shut down nearly all refugee admissions, and certainly a focus on shutting down Syrian refugee admissions. So in the first week of the presidency, the president issued 5 executive orders. 3 of those were on immigration. You often hear that the Muslim ban was the first executive order issued by the president. It wasn't. There were actually a few executive orders issued before that, 2 of which both signposted and in some cases put into effect massive revisions of our interior and border enforcement policies, and also put in motion changes to our asylum program as well. We may touch on some of that. We may touch on the state of the litigation regarding the Muslim ban, the nationwide injunction there. There's also an injunction that largely defanged one of the administration's attacks against so-called sanctuary jurisdictions that have adopted policies to try and limit the involvement of their state and local officials in immigration enforcement efforts. But I wanted to, for now, turn to our panelists. So I want to ask each of you to speak for about 8 minutes or so about what you think are the most pressing issues in immigration refugee, the immigration refugee space today. I come from CAP, right? It's a progressive, multi-issue organization, and I see from inside the building that there are obviously a lot of issues from energy, from the environment, from protection of LGBT communities, from criminal justice reform issues, sentencing and policing issues. Everyone sort of feels that their hair is on fire. But even within the immigration space alone, the threats are really everywhere you look. And so one of my challenges certainly is figuring out where I'm going to prioritize my time. And I'm curious to hear from you all how you decide how to prioritize your work, and also just generally looking at the space, where do you see the greatest threats right now?
So I always have to give a disclaimer when I speak, which is I'm speaking on behalf of the National Association of Immigration Judges, not in my capacity as a representative or spokesperson for the United States Department of Justice or any of its components. Because I have to say that all the time, I have to have a little fun with it, and I say that, when we have competency examinations and try to see if people are oriented to space and time, if by the end of my remarks you think I'm speaking on behalf of the Department of Justice, please check in to your closest local mental health clinic, because you aren't with it. I also like to let people know where I'm coming from on a personal level. My background was 10 years in private practice for immigration law firms who helped immigrants come to the United States. My street credibility comes from the fact that I was lead counsel for INS versus Cardoso Fonseca, the landmark asylum case which sets a more generous standard for asylum seekers, proving that you only need a well-founded fear of persecution, a reasonable possibility. Thank God that has held up over time. I've been an immigration judge now for 30 years. I don't know where the time went. I still see things from the outside, I think. And one of my frustrations, and something that is shared by my organization, is the fact that the immigration court is this forgotten piece of the enforcement puzzle, and that we're not well protected structurally in the situation where we are. I know we have a varied amount of involvement and past knowledge with the immigration law, so I want to remind people of some basic things which I hope the experienced ones will forgive me for. We are a civil administrative court. That means that even though we are doing death penalty cases, we do them in a traffic court setting. Why do I say we're doing death penalty cases? Because if I decide wrong, or if I decide right but follow a harsh interpretation of the law, I may be sending someone back to a country where they are going to lose their life. It's a pretty sobering job. And why do I say that we do it in a traffic court setting? Come to one of our courts. There's one in Arlington. There's one in Baltimore. You guys are from all across the country. There are 58 immigration courts across the country handling 585,000 pending cases right now. 585,000, with approximately 300 immigration judges in field offices. You'll see a number of about 318 at last count, but 20 of those are exclusively or predominantly management and supervisory and don't have a docket. So I did the math. 300 divided into 585 would give us 1,950 cases. I have around 3,500. I know colleagues that have more than 5,000. We need to assure that due process is provided in our courts. That is something that is in the statute that every immigrant is entitled to. And I don't know how you can do that with the structure being housed in a law enforcement agency that treats us as attorneys of the department, of people who can be insubordinate if we do not follow our supervisor's instructions on procedurally how to handle cases. I can tell you in the 30 years I've been a judge, no one has said grant this case or that kind of case and deny this case or that kind of case. They trust my legal judgment. But they tie my hands when it comes to docketing issues, which are just as important, because sometimes administrative issues can undermine a judge's ability to do what they need to do. So our association always has two things in mind. Short term, resources, resources, resources. The Migration Policy Institute did a study over about a 15-year period. There was a 300% increase in the allotments and appropriations to immigration enforcement, and only a 74% increase to the court during that time, even though the courts were known to be underfunded at that time. So as one of my colleagues said very aptly, when you've got a hole in your gas tank and you pull into that gas station, of course you need more gas, but aren't you going to fix the tank? Nobody has wanted to fix the tank. It gets kicked around in Congress because immigration law is really hard. It's as complicated as tax law. Even the courts acknowledge that, and I say it's more complicated. Where is the TurboTax for immigration law? You get to that first dividing point, and there's more than a binary choice. So we need to make sure that we have a transparent and independent structure for this extremely complicated area of the law. And in order to do that, our organization and many others have advocated the creation of an Article I independent immigration court. So of course, from my vantage point in the trial court, that's the most important thing. It's nice to have a narrow issue in front of me. Some people argue that comprehensive immigration reform is the only way it will get done. Others are now more inclined to piecemeal immigration. I say, look, this is the legislative sweet spot of immigration reform. If we have a more transparent court system, it's more efficient. People accept the decision of the trial court judges without appealing it. The ACLU lawyers don't feel compelled to file class actions. They have faith in us. And it happens on a macro level and on a micro level. I will never forget the time that I was talking with a respondent who I had to order removed. And I had given him my best kind judge marks, right? I had listened to all this irrelevant, extraneous, heartbreaking information about his life, which meant nothing legally to the case, because he was an aggravated felon, unquestionably one of the offenses that prevented me from giving him any relief, and he was from a country where he didn't have a risk of danger to his life. By letting him tell me what he thought was important, at the end of that case he said, I'm really heartbroken that I'm going to have to go and be separated from my family, but I can't imagine anybody listening to me better and being more sympathetic than you did, Judge Marks. You let me tell you about my wife who has MS and my autistic son, and how I'm the only breadwinner, and how I've been here since I was a child, and I don't even speak the language back in my home country. But he goes, so if I can tell you all this and you still have to, and you listened, but you explained to me what the law provided, I'm not going to do any better on an appeal with somebody else. I'll take your order and I'll leave. And as I said, it clearly would undercut the class actions, which are deservedly filed when judges are not able to control their dockets in an effective way. It was an interesting discussion in the plenary about how much judges should speak out. I've used my union label to be able to speak out because that's my personality. I was rooted in advocacy before I became a judge. But I also understand the flip side, that we can't appear to be prejudging cases and that the canons of judicial ethics prohibit us from commenting on substantive changes. But here is a procedural, due process-friendly reform that everyone should like, liberal and conservative, because it will be more efficient and it will be more fair and it will be transparent, which is what courts should be and which understandably law enforcement agencies are not. So that's my 8-minute pitch.
Hi, I want to thank the organizers for inviting me and for doing all the work to get me here. We've already heard a little bit of pushback on the panel premise, a nation of immigrants no more, which sort of suggests that we've ever been a nation of immigrants in anything truly meaningful. And I think it's always been an aspiration. It's at many times in our history been far from the reality. And there are other reasons to push back on the premise. Of course, it elides a history of enslavement, forced migration, and colonial conquest that also is part of our history and that is not a part of our nation of immigrants narrative. And I think we need to own that past as we talk about the present because it helps us think about intertwined problems and potential solutions. I wanted to use my time today to talk not about the immigration court system as an administrative system or immigration law as administrative law per se, but to instead link up my concerns about what's happening in the current administration to broader concerns about conversations around criminal justice reform. And when we think about immigration, we often don't think about criminal justice reform, and I think that's part of the problem, and I'm hoping in my remarks to get us all to think about remembering immigration when we think about immigration or when we think about criminal justice reform for a variety of reasons that I hope will be clear at the end of my 7 minutes remaining. So Attorney General Sessions has made it quite clear that the Department of Justice's take on criminal justice reform conversations is that they haven't heard any of them and that we're making a return to tough on crime policies. So there's been memoranda to U.S. attorneys clarifying the need to pursue mandatory minimums in all cases, including low-level cases where typically they may not be pursued. And I think we also have, alongside that, the Attorney General prioritizing immigration prosecution as part of the crime control policy. So we've had, again, a memoranda in April going out to U.S. attorneys making clear the fact that they were to prioritize immigration crimes as a subject of their prosecutions, that they were to appoint in their office a point person on border security issues. So this is a critical component of the Justice Department's crime control agenda. It is situated within a crime control agenda that is making a return to tough on crime policies that have been largely rejected both in political spheres and in academic spheres for some time. And so, in fact, when Sessions made his push around mandatory minimums, we saw senators, a bipartisan group of senators, Cory Booker, Mike Lee, Rand Paul, Dick Durbin, uniting together to suggest that maybe this wasn't such a good idea, that we have sort of a long track record of academic evidence that this is not necessarily effective crime control policy. What it does is, what it has produced for us is a sort of a depressing legacy of racialized mass incarceration, and maybe that's not the move going forward, but that seems to be the direction that we're taking. And I think it's important to emphasize this coupling of the emphasis on immigration prosecutions and the emphasis on tough on crime policies, because they will have a sort of a mutually reinforcing effect. We need to be mindful of the fact that immigration prosecutions have played a leading role in the expansion of the federal carceral state. That was kind of the reason that we saw the proliferation of federal prisons once we had the criminalization of immigration. And when we have a focus on immigration crimes, we have the potential to really expand the federal carceral state further. So for those reasons, I think we can be concerned about federal criminal justice policy in the direction that it's taking, both in terms of sentencing generally and in terms of the focus on immigration more specifically. I think we also need to be concerned about the direction this takes us at the state level and the local level. We had in the 1990s changes in the immigration law that facilitated the participation of state and local governments in immigration enforcement, most specifically the development of the 287G program, which allowed for states and localities who wanted to contractually participate in immigration enforcement under the supervision of the federal government to do so. And that program sort of sat without much meat on the bones until the post 9/11 era, and we saw a real expansion of those 287G jurisdictions in the late Bush term and continuing it through the early Obama years. And also in the early Obama years, the kind of addition of the Secure Communities program, whereby any state or any local official who made an arrest ran their information through the database, and that information was also run through DHS databases to check on immigration status, and then immigration officials could communicate with states or locals to please hold an individual while they decided whether or not to pursue immigration charges against them. For a variety of reasons, these programs were problematic. There were numerous academic studies that suggested that jurisdictions that had 287G agreements were more likely to engage in racial profiling than those that did not. There was a well-respected academic study that suggested that Secure Communities was rolled out in a way that coincided not one whit with public safety concerns or even with levels of unauthorized migration, but correlated directly to the number of Latinos in the jurisdiction, which suggested the racial overlay of these programs. And in response to both the academic studies and the concerns of local officials who felt like these programs and their participation in immigration enforcement were creating problematic strains in their relationship with their communities and in their ability to do their core jobs, the Obama administration began to scale these things back. So we saw a rollback into 287G agreements. We saw the sort of reduction of the Secure Communities program to the priority enforcement program, which was supposed to prioritize those individuals who would be identified for purposes of immigration targeting after they had contact with local law enforcement. So this was responsive to advocacy and also responsive to what academics were saying about what was working or not working. And again, in keeping with what we've seen with regard to sentencing and the focus on immigration prosecutions, we see the new administration backtracking, so doubling down on the things that we know don't work and that we have seen have had some problematic consequences. So the administration in those earlier, you mentioned that before the travel ban order came down on that Friday, there were 2 executive orders that came down on that Wednesday that dealt with immigration enforcement, including interior enforcement, and made it very clear that the new administration planned to promote the expansion of the 287G program. And we've heard additionally that they plan to return to Secure Communities, full stop, away from any form of priority enforcement. So any lessons that we might have learned about what works or doesn't work in terms of coupling state and local law enforcement efforts with federal immigration enforcement, totally thrown out the window. And in fact, I think kind of taking one step further down the road, the anti-sanctuary city rhetoric that we hear is really meant to, at some level, encourage and promote informal cooperation, not legally sanctioned through either Secure Communities or 287G, but to send a message to state and local law enforcement who want to, that if they desire to participate in the immigration enforcement project, they should do so. And for many reasons, I think, for all of the same reasons that the other programs have been problematic, this too is problematic. We can combine this then with the Department of Justice's stated intent to step back from formal investigations and consent decree enforcements around issues of racial profiling at the state and local level, and think about what sort of a mix we now have for creating conditions on the ground that optimize the possibilities of racial profiling around a purported immigration enforcement agenda in jurisdictions that are so inclined. And so I think it's really important to think about how these pieces are going to be working together to create bad conditions for immigrant communities or for communities that are perceived perceived as outsider or other. This really, in some ways, I think, is a free pass for racial profiling as a means of ginning up immigration enforcement, even when it comes at the expense of public safety and even when it comes at the expense of community cohesion. And all of this, I want to emphasize, just in closing, I think I have used all my time, probably I have. This is a highly racialized sort of notion of what works and what doesn't work. And I think this was really brought home to me during Attorney General Sessions' speech to the Border Patrol agents on the southern border in Arizona in April, where he talked about defending that quote unquote narrow sliver of land against essentially machete-wielding maniacs, and the entire world seemed to break down into a dichotomy of quote-unquote citizen ranchers on the one hand and the machete-wielding MS-13 on the other, a totally unnuanced view of what happens on the border and who crosses it, that I think unfortunately is driving both immigration and criminal justice policy, particularly at the border. But as the memo to U.S. attorneys throughout the country makes clear, for Sessions, in some senses, the border is everywhere.
We're going to go to Liam. I did want to just flag that very last point there. The National Border Patrol Council, which is the union for Border Patrol agents in the country, has a podcast. And they begin their podcast with a recitation of the Night's Watch creed from Game of Thrones, right? This idea that they are standing watch against invading hordes of zombie killers. But that is their self-conception of how they view their role. And that's obviously consistent, certainly, with what Jennifer just flagged.
Well, I wanted to start positively, but that
only up. You can only go up.
And I will still do it. I didn't have prepared remarks, so I wanted to go off the flavor of it. So I feel like we need an uplifting moment here. So now I will do the uplift thing. I can do a downlift, but I feel like we need an uplift, so I'll do an uplift, and I'll say why we. What are the structural factors that at least protect us so that we maintain this nation of immigrant status? So I think you have to realize we do have some positive factors, and this is not meant to be Pollyannish. I'm just focusing on the positive because I only have 5 minutes. So let's start with this. First of all, the corporate, so let's start with this. The sort of corporate establishment, one of the big things the president is a big fan of is meeting with all the high-tech executives. And he does this repeatedly over and over again. And Jared Kushner does it repeatedly over and over again. Those high-tech companies are full of employees that are not only are all immigrants, let's start with that, but are all extremely active and extremely vocal. And when the travel ban happened, which didn't affect almost any of them because almost all of them are from India and China and are not from the 6 countries that were focused on part of the travel ban, this group of employees went nuts and insisted that their companies do things. Many of them donated to the ACLU, many of them did other things. And frankly, one of the interesting things is a lot of these employees are stuck at their particular employers due to problems with our high-skilled immigration system, but what you would probably see is if they actually had labor mobility, they'd move from some of these companies that, are going and visiting with the president and doing things and say, if you don't force the president to do certain things on immigration, we are gone. We are out of here. Now, they can't do that because they'll lose their green card application, and a lot of them are waiting for 20, 30, 40 years to do that. And so if you want to talk about one reason you'd want to fix the high-skilled immigration system, it would be to get all of these employees who are super progressive and super very active on the immigrants' rights front to actually give them the freedom to do this. But in terms of, you see this all over, not just in the high skill, in the housing sector, every big home builder in America is telling the president, I can't find anybody to build homes anymore. The cost of building homes has doubled in terms of labor. Now, some people say that's great because there's Americans, but there's not like Americans are coming into the sites for the double of the cost. They're just not, some of these home building things are not happening. And this is construction, which is still easier to find people than agriculture, which is absolutely now devastated under these new policies. And so the point is, even if they don't listen to us or they don't listen to the immigrant community, they do listen to the biggest growers, the biggest tech industry people, and all of that that consensus is baked into the cake and will always be baked into the cake now. We are now a global economy dependent on being a nation of immigrants. Whether we want to or not, we will do it. And you can only not listen, and you can only pretend to avoid this for enough time until you ruin whole industries of companies that are dependent on this. And then those people will make the president understand, whoever that president is, that you can't do that. So that gives me comfort. That's number one. The thing that gives me comfort, number two, is that this is the friendliest court environment we've ever had as people who advocate on behalf of immigrants' rights. I just finished being sort of the evil person that everybody hated at the Department of Justice, who defended the priorities of the Obama administration vis-a-vis immigration enforcement, and I noticed this, even going into court as the Obama administration, the judges hated me. They're like, oh, you're evil government trying to enforce the immigration law. You're terrible, terrible people. And this is just, at the end of the Obama administration, we were not doing enforcement-oriented, new initiatives. We were just defending the statutes that were being challenged, and even then, the courts were like, "How dare you defend statutes on the books? This is terrible." And so, from the standpoint of actual new initiatives that are being done for actual enforcement purposes, those are not going to be met in a very friendly judicial environment right now. If you look at, for instance, the change in the Fourth Circuit, if we were having this discussion in 2008, would have ruled, if they had gone en banc on the travel executive order, they would have ruled 11-3 the other way. But now they ruled 11-3 this way, because those courts, with the exception of the Fifth Circuit, almost every court in America has dramatically shifted due to an influx of new judges that were appointed over the last 8 years. So it's going to be very hard and the ACLU has a lot of cash now, so God bless, for the changes to actually take effect. Every change is going to be a hard-fought, bloody battle, which will take us to probably the end of this first term. And so it's going to be very hard for any change, I think, to make its way through it. And I mean, the Supreme Court, what are they going to do? Are they going to accept 52 immigration cases a year? They're not going to do that. So they may accept, 2 or 3 or 4. Maybe they'll do 5 in 1 year. But they're not going to do 50. And so the point is, a lot of these policies aren't going to be able to get done. Third, the bandwidth is what the bandwidth is. There were a lot of positive reforms done under the Obama administration, but that took 8 years. It was a very long process. And so we're all worried, okay, Trump's going to change everything. It's going to be a disaster. It's going to be a nightmare. They are not adequately staffed to do that. They don't have a lot of people and there's only so many hours in the day, and there's only so many people there. And so the point is, they can only do this at the pace they can do it in. And between that bandwidth issue and the litigation issue and the court issue, it's, yes, things that are not pleasant are coming. I'm not saying that, but I'm just saying the rate at which those unpleasant things are coming. We don't have to fear that all of them are coming tomorrow. But that does create a false complacency, which I will also talk about later, but I'm trying to be positive now. And then finally, in addition to all of that, is that, there is this issue where anytime, unlike positive reforms, if you pass a positive reform, it's not always clear that someone has standing to challenge it. When you create a negative reform, someone has standing to challenge that, always. So that's a difference too, which is, let's say you do something that makes it easier to apply for, an investor visa or something. It's not clear that somebody's going to be able to challenge that. Every time that you harm somebody, that person can go to court and say, "You harmed me," or most times. And so it's easier to challenge things that are being done that are enforcement-based, as opposed to initiatives that are being done that expand the rights for people in the immigrant community. So with that, I'm not saying everything's good. I'm not saying that at all. But we have those positive things that make negative change much, much harder to accomplish. And so that's why you see things like DACA not being eliminated entirely, and you see things like, discussions being had on how to alleviate. So you have these bills being done by Cato and by some very conservative members of the Republican Party on how to alleviate worker shortages in construction and in ag. They talk about these state-based work things because they realize these are problems that exist. Now, I would ideally like to solve it by regularizing the status of the people here, but we'll figure that all out. But I'm just saying that's people realize that these problems are happening, and the more they squeeze on that balloon, the more the air is going to have to come out. Now, do I have any more time? What time? 2 seconds? I'm done with my time? Okay, so I'm done with my time. So we'll get back to negative stuff because I don't want you to think I'm completely naive, but we'll do that later in the panel. So.
Hi, everyone. So I was going to talk about one sort of definite negative that's probably coming down the pike in terms of things that we have our eye on, and then one sort of question mark. Basically, the day after the election, I think a lot of us were walking around like zombies, wondering what just happened, feeling, sad, depressed, fear, definitely. One of the nice things about working where I work is that we all got to come to the office the next day, and right away we sat down and we said, what are the threats? What are the threats that we need to start preparing for? And one of the first threats that we sat down and said that we needed to start preparing for was something called expedited removal. Many of you may not know what that is. Many of you probably do know what it is. It is a type of summary administrative removal procedure where basically an immigration officer can order you removed and deport you. And in most cases, you don't get a judge, you don't get a hearing in immigration court, you don't get to go to even the traffic court that Judge Marks was talking about. You don't get to federal court. Leon was just mentioning that in most cases you do something bad to someone, they can go to a court of law to complain about it. Expedited removal is this thing where it's a little bit Kafka-esque, but an immigration officer can completely change your life and send you away, and there is almost nowhere you can go to complain about it. So basically, the immigration officer is your prosecutor, your jury, and your judge. This has actually been going on since 1997 was when it first went into effect. For the last 20 years, it has been limited almost exclusively to either people who have never entered the United States, so they are arriving at a port of entry at an airport or at a land border, seeking admission to the United States, or it has been applied to people who have just recently entered and have been arrested within 100 miles from the border and who cannot prove that they've been here for longer than 14 days. During that time, there have been tons of human rights reports, including a major report that was actually commissioned by Congress because of reports of abuses in the system that have documented under expedited removal, all of the erroneous deprivations that have happened, the people who have been sent back to countries where they fear return, the people who have been wrongfully expeditedly removed, even though actually maybe it wasn't supposed to be applied to them at all, or even though there was actually nothing wrong with their visa when they were coming in at the airport and they shouldn't have been deported. I should mention that expedited removal does allow, if the one type of relief from deportation that you can apply for is essentially asylum and related humanitarian protection. So if you have a fear, you can get a threshold screening with an asylum officer who gets to decide whether you ultimately will be allowed to apply for asylum. And if you pass that threshold screening, that's the only situation in which you get to see an immigration judge. Or if you fail it, actually, you can go to an immigration judge to appeal the failure of the threshold asylum screening. So the reason why expedited removal is in this situation where you basically can't come to court is that in 1996, when Congress enacted expedited removal, they enacted a number of jurisdiction stripping, court stripping rules that affect a lot of other things, including expedited removal. But expedited removal is the one area where it is almost impossible to get into court. even if, for example, you've entered the United States, you're a person, you're protected by the Due Process Clause. The government's position, even under the Obama administration, was that if you were here for, you were inside the United States, but you were subjected to expedited removal, you have very limited, if any, or maybe no due process rights under their position, and you're not protected by the habeas corpus suspension clause. So what does all of this mean for now? So when Congress enacted this in 1996, they said that expedited removal could be applied to people inside the country who up to a 2-year limit. In other words, if you can't show you've been here for longer than 2 years, and it can be applied anywhere in the country. But the reason why it hasn't been applied, well, I won't speculate about the reason, but there has been reports, and maybe others can tell you, that the reason why it's never been applied to that limit is because there's a big question mark. There's a big constitutional question mark. People have been living in this country for 2 years, and you're going to say that we can just deport you by filling out a piece of paper, and you never get to go to court to challenge what's just happened to you. You can't even go to court to challenge whether you even are properly subject to expedited removal. Maybe you've been here for 2 years and 1 day, but you have apparently, under the expedited removal system, almost no right to come to court. So the day after the election, literally the day after, we were, thinking about what the biggest threats are, and one of the biggest threats was this law that's been sitting on the books and that has never been used to its fullest extent. It's only been used for people who are apprehended within 100 miles of the border and who can't show they've been here for longer than 14 days. So we saw right away that this was a huge risk, that the new administration, which had announced in various campaign statements and elsewhere that they were interested in deporting as many people as possible, as quickly as possible. Expedited removal is a way to deport hundreds and thousands of people with almost no process and no check on what's going on, no judicial review. And so that was our prediction. We started, working on it right away. And then, I forget what day it was, but then the executive order came out, January 20th. 27th, was it? Right after the inauguration, we got an executive order. One of the many horrible things in the executive order was that the president directed the DHS secretary to apply expedited removal to the people that it says in the statute you can apply expedited removal to. Now I'm running out of time, so I'm going to start talking really fast. Basically, this is a major problem. This is, people can, if they were to expand it to anywhere in the country, this means that people who are taking their children to school can be whisked away, and put into this processless process and deported within a matter of hours with very little recourse. So that is an issue that we're very concerned about, that we're working on, we're preparing for, which is code speak for working to sue over. And then the other issue I wanted to flag really quickly, which is a big question mark, is what is the situation with the Deferred Action for Childhood Arrivals program, the DACA program, for young immigrants who were brought here as children. And the Trump administration has said that that Dreamers should rest easy, that they're going to work something out that'll make us all happy and proud. The February 20th Kelly memo said in a footnote that one of the only things that was not going to be affected, that was going to remain in place, was the DACA memo. They issued a Q&A at the same time when they issued the February 20th memo that said, does this memo affect the DACA program? That was the question. Answer, no. There's only one word on it. Since then, we've seen, I think Tom was mentioning the new USCIS statistics came out showing that there's been basically no change. They're continuing to grant renewals and DACA applications. But the one thing that we have seen is that there's been a handful of individual DACA recipients who have had their DACA terminated. One woman that I and my colleagues represent is named Jessica Colloidal. We were just in court yesterday in Atlanta over her case. She she's had deferred action actually for even before DACA, and she was one of the young people who inspired the whole DACA program. She's gotten DACA twice, And her recent renewal application was denied, and her DACA was abruptly terminated before it was even set to expire. And she was given basically no explanation, although the administration has gone to the media and told everyone that she was actually a felony convict, which, as it turns out, is not true, and which this was all based on a driving without a license incident from 7 years ago that the government has known about all of this time. So, which the government has now, because we filed our suit, they've now conceded that she is not a felony convict. And one of the questions the judge asked the court, the government has conceded very interesting things in our case. One, the DACA policies are still in place. They have not changed. Nothing has changed about the DACA policies, in addition to conceding that she's not a felony convict. So one of the $64 million question, as the judge said yesterday, that he asked the attorney for the government point blank is, why are we here? Why are you terminating this woman's DACA? She's not a felony convict. She's a exemplary young immigrant who just wants to go about working and living her life. And the government had no answer. So I think that's a question mark. Are they going back when they do go through these renewal applications and combing through everybody's history with a fine-tooth comb and trying to find some excuse to terminate people's DACA? We're not sure what happened in her case. She's not the only one that this has happened to. And if it's the case that you can have the same facts, because she has had no subsequent thing happen to her, or that she has no other history other than the same history that the government has known about when they granted her DACA both times. But if DACA means that you can just be doing the same thing you've done the whole time and have no relevant criminal history, but they can still take it away, basically arbitrarily, as the judge said, and with no explanation, what does DACA mean anyway? So that's one of the questions.
Well, awesome. So I've got a couple of questions just to spark conversation, and then we'll ask for audience participation. So the first thing is just, I'd love to get a sense from the folks, you've heard each other speak now. Were there any themes that came out of that were interesting to you that you wanted to jump on immediately and respond to? I definitely thought that one of the things that came out of a couple of these points here was thinking through what is the real life impact of the current uncertainty and the policies on individuals and their families, right? So within the DACA community, you obviously have, from this uncertainty, a strong level of fear. That the numbers may suggest actually that you're seeing people combating that fear and actually coming forward and saying, look, this is the one lifeline I've got. I'm going to go for it with my renewal. But similarly, I think we're thinking, to look through sort of fear for families, thinking through also what the criminal consequences could be throughout the country. The really striking thing that Jennifer mentioned is you're now seeing, and I think it's all in 94, I think it is, U.S. attorneys' offices in the country are all being directed to focus on immigration enforcement, criminal prosecutions, right? So that's a very, very big and new change in policy. Were there other themes that sort of came out of this that you want to comment on?
I think one thing that struck me was kind of putting your two presentations together. We have this interesting phenomenon where we know that the immigration courts are not properly resourced to actually process cases. And the solution is not to properly resource immigration courts, but to take as many removals out of immigration courts as humanly possible. And you do that by expedited removal, right? Because then you don't go to immigration court.
It's a very cynical result of having failed to resource the courts appropriately.
The other thing that we'll see is the increased reliance on immigration detention as a mechanism of leveraging stipulated removals, where people just say, I give up and I'll go. And that's another way of avoiding immigration courts. And so, so it's this cynical ploy of kind of saying, well, our immigration courts are under-resourced, so let's use all these other mechanisms. And we know those mechanisms to be incredibly under-equipped when it comes to providing due process.
And the language of the, not even just the executive orders, but the implementing memo by Kelly is that we're going to deploy judges to the border. There's, I am not a member of the armed forces. I never have been. I'd be a very bad soldier. And that was a term that was really offensive to the judges, but language matters. And this idea of taking judges out of their sitting courts in non-border areas and the idea that the border is everywhere, you're absolutely right. Judges are being taken from their home courts and being sent to detention areas near the border. It creates this it further undermines the system because from a productivity point of view and a sensible allocation of resources, it's unbelievably expensive, it's a total waste of time, and it's pushing a dysfunctional court that's teetering on the edge of keeping it together into chaotic dysfunction. But it also, I think, has a very clear chilling effect on the public that we serve and makes people afraid to show up in court, which is the most dangerous thing they can do. That virtually is going to guarantee their order of removal, right? Because the law is very harsh in that way. And it just, it's not helpful when you were talking about the secure communities and the 287G. People are afraid to come to court. People who are undocumented won't come as witnesses because they know they are very likely to be considered a priority now because anybody is a priority. We no longer have a true sense of priorities. And one of the things that strikes me that I wanted to throw out to this audience is that we hear prosecutorial discretion discussed as if it's a dirty liberal word. And we need to go back historically and realize it is a resource allocation tool that has been in effect since time immemorial for you to decide if you have less judges than can handle the 585,000 cases, which ones, Mr. Prosecutor, should go first. And that there needs to be some realistic solutions to that, not just we'll cut everybody's rights and then we don't have to worry about it.
The only thing I would say is, I think a lot of this is going to be determined very quickly in terms of there's three things that are all happening in the next 3-4 months to look at that I think will be interesting. The first is what will happen very soon in this decision, Jennings versus Rodriguez. This case has been called many different things going up. But the question is, if you can keep people in mandatory detention for longer than 6 months, it will change the nature of who's in the facilities. Because one thing that's been happening on the appropriations front, even though Congress has taken out the number of beds in terms of the requirement, they're funding the beds at a level of about 39,000 beds per day, meaning 39,000 people can be detained per day, and the president has asked to raise that number to 51,000. And so if you take three factors, you take 51,000 beds, you take the fact that there's now funding for 1,600 new ICE agents, 1,000 agents, 600 supports that funding's been given, so those people are online to start getting hired now. So those people have to do something, and what they're going to be doing is putting the people in the beds. The question will be, what will happen if you're allowed to keep people for longer than 6 months, what's going to happen is the same people will be in those beds for all of that time. And so there will be no pressure to shrink or add to the resources of the detained immigration courts in order to get people out in 6 months. If you have to keep people only for 6 months, then what will happen is all the resources will be deployed, but perversely what will happen is they're going to have to get more and more people into the detention and removal system in order to fill the bed. So it's actually less people get deported the longer you can detain people, weirdly enough, but more people will actually end up being put in the removal system to feed the pressure of the detention bed funding if you actually have to keep people in beds, but you can't keep them for longer than 6 months because you're going to be deploying more resources to end those cases. So either way, it's not a good scenario, but the point being, you will see two very different outcomes, and my concern is, if we're in scenario 2, not that I choose scenario 1, I don't choose either scenario, but I'm saying if we're in scenario 2, you will see, I think, much more vigorous immigration enforcement in the interior because it will be a natural consequence of having to keep beds filled when you cannot keep them filled because of lengthy stays, because you got to get people in and out after 6 months, and you have 1,600 new ICE agents to do this with. And so that part of it concerns me. That has nothing to do with specific changes in the immigration law, but that is something we will all feel because it's just agents going and looking for people in undocumented status to place into removal proceedings. So that, I think, so I had my whole positive thing, but if you say where's the challenge, I think that's the challenge.
I was going to ask you, what happened to the optimism?
Well, no. I'm saying that's I didn't have enough time, but that's the challenge in terms of the layout of the next 3 to 6 months.
Can I tease out one thing on that? So, I mean, the other alternative to that scenario, and that I was watching Jenny on that, because they're also involved in that case as well, and argued it in the Supreme Court. Is that the other alternative, obviously, is that those agents end up doing what you guys are talking about, which is finding ways to encourage people to either do STIPs, which can be done quickly in detention, right, through expedited removal, through an expansion, or potentially also there's another process called reinstatement of removal, where if you have a prior final order of removal, you can similarly be picked up and without going to court, get that order effected. So one thing I think is it would be helpful to talk through a little bit is, especially in a world where due process is being limited because people can be removed extrajudiciously, that seems, in this setting, to be an important time to talk about the role of lawyers and access to counsel. And so we are seeing now efforts by nonprofit groups, by cities and states in unprecedented ways to step up access to funds to support people getting access to counsel for a lot of things. People who are in deportation proceedings, trying to set up clinics for folks who might have an opportunity actually to change their status or adjust their status to some lawful immigration status, but who may not know it and may not have access to a lawyer to figure that out. I want to talk, if you could talk through sort of what role do you think lawyers have to play in this moment in time with what we're facing?
So starting on my lower level, it's universally agreed that lawyers improve the process, that it goes more effectively and efficiently. People know what their rights are. They know what's worth fighting. They know when they're not going to win, and they don't want to stay incarcerated if they're not going to win. And a disturbing thing that I've heard recently, as I've been doing a little bit of lobbying work around these issues this week, is a concern that the Department of Justice may monkey with the funding of the legal orientation programs, which give presentations of Know Your Rights, and that's funded by the government. Again, another reason why Article 1 is really necessary, to allow the judges to have more ability to be involved in that rather than to have it filter down through many levels of the Department of Justice, with all due respect to former high-level DOJ people who might be in the room. And communities have rallied. I'm lucky to be from California, where both on a state level and in the San Francisco Bay Area, where the city of San Francisco, the county of Alameda, they are funding nonprofits to bring cases into court for certain vulnerable populations. Both the San Francisco Public Defender's Office and the Alameda County Public Defender's Office now follow their immigration clients into the removal process because they realize that what happens in the criminal court is almost secondary to what the impact would be in the removal proceedings. And so we definitely need more lawyers' involvement in that level and ways to strengthen the system, moving towards assuring that unaccompanied minors, people with mental competency issue, how can you give them due process if they don't have lawyers to represent them? And if you can't, then doesn't there have to be some government funded way to appoint counsel, which of course I personally hope will open the door to universal funding for immigrants in proceedings, but that's really a way off.
I mean, really briefly, on counsel, we had a case that was trying to get counsel for unaccompanied children, actually, including unaccompanied children, and that was where this pesky jurisdictional issue came in, and although we had done okay in district court, we ended up getting our case dismissed by the Ninth Circuit, who held that there wasn't jurisdiction to bring a class action over this question of whether children in immigration court were entitled to government paid for counsel. And so the Ninth Circuit's sort of reasoning was that, this is something that the children themselves have to raise in their immigration proceedings, that it's so bound up with their immigration proceedings that it can't be litigated separately and it shouldn't be litigated separately. And this is, obviously there's some conundrum there, although the Ninth Circuit felt that it was a conundrum that could be overcome, which is that how are children who are unrepresented by counsel supposed to raise this issue. So we're still continuing to press that issue through individual children's cases, trying to walk that line and figure that out. They obviously can't be represented in immigration court, because if we represent them in immigration court, their claim is immediately moot. The question is whether there are ways to do it despite all of that. So that's sort of one area where we're still, obviously we're still litigating it. In the expedited removal realm, lawyers are critical. On the other hand, they almost never can get involved because the process happens so quickly. It's basically a black box. I think Becca Heller was talking about, the black box at the airport. Well, that actually is something that the whole process, whatever process there really is, there is almost no process, but whatever the process is for expedited removal, it is basically a black box where you're at least, if you're not someone who's expressing a fear, you're not entitled to an attorney, even one that you want to pay for
Right,
yourself.
even retained attorneys are not allowed access, which is surprising to a lot of people.
Right, and so there's actually right now in the Ninth Circuit, there's a pending it's not en banc, it's an en banc petition over this question, whether in the expedited removal process you have a due process right to counsel. And the three-judge panel held that the answer was no. And so we'll see what the Ninth Circuit judges do. So it's just quick follow-up on counsel.
Just a quick thought, because I did have to, not willingly or thrillingly, but just part of a different, it's part of a horrible circumstance of just we had a surge of unaccompanied minors all coming at one time, and then the lawsuit was filed about giving counsel. So I did have to lead the defense on the issue of did you have a constitutional right to counsel as a minor? And the complication was, well, if you had a constitutional right, then what that meant is if the Congress didn't appropriate that money, then that would mean that you literally couldn't do immigration enforcement on minors. And this created a complicated scenario for the administration in a world where we were at 70, 80,000 minors coming into the United States in one fiscal year. And so it became just a terrible confluence of circumstances. But moving forward, where the numbers are lower, I think the role of counsel is extremely important, but I think it'll be interesting to see. I think expedited removal is important, and it's important to focus on, but I think the lower hanging fruit, and I think you will see this, unfortunately, will be this denial of continuances, which will be, there was this report issued by the Government Accountability Office, which said that the immigration court gives too many continuances. And they said, stop doing it. And the reason you give a continuance is to let people have time to find an attorney. You don't just give it for fun, because you want to give it. You give it because the person...
Another reason you don't want your immigration judges subject to being charged with insubordination for not following instructions like that from their supervisor.
Right, exactly.
Sorry, I have to keep putting in that page.
No, fair enough. But I'm saying, if I had to predict if I was going to Las Vegas tomorrow, I would probably put a wager on the fact that some memo like that will come soon, saying stop giving continuances, or give one or two, whatever it is, and they should be for X amount of months, and that's it, and there shouldn't be any more. Right. And that's where I think this issue of right to counsel is going to ultimately get raised. This is where I was, and I will say this: there are cases I defended which upset people, but I never would have defended this thing that happened with the Northwest Immigrants' Rights Project, that was the whole point of this, which is if you couldn't assist people without being their counsel, you could never then raise their claim. Because our point was just kind of give some shadow assistant to a kid so he could raise this claim constitutionally to the court. But then if you actually get rid of the right to do the shadow assistance, then you've ruined the whole ability to give the kid the ability to raise that claim in the normal petition for review status. Now, the other complicated thing that happened in that Ninth Circuit case, it turned out, through no coordination, seriously, which was just shocking, just happened as we learned it, that the judges themselves, just as pure human beings, couldn't bring it to their own hearts to deport kids without counsel. They just weren't doing it in the Ninth Circuit. That doesn't mean it wasn't happening in other circuits. It happens in other circuits. But we went around and we started talking to all the judges. We're like, are any of you deporting kids without attorneys? And it just wasn't happening. And so this was one of the complicated things about raising that case in the Ninth Circuit, was that the judges themselves didn't have the heart to do this. So there weren't active plaintiffs you could actually bring. There were plaintiffs you could bring who were in removal proceedings, but all of those kids were getting continuances because the judges were,
But it was the judge's hearts, but it was
Yes.
also the protection of the Ninth
Well,
Circuit.
well, sure,
That
fair
it
enough.
gives us some, and I've often said I couldn't practice immigration law outside the Ninth Circuit.
Sure.
Because that protection is so important.
Engineer, you had a thought also.
Yeah, I think when I'm thinking about counsel, there are a couple of themes that spring up, and one is just what we're going to see is what we already have, but increasing local variability in terms of what it means to be an immigrant, what it means to be undocumented, what it means to have a potential ground of removability, and that is that in some jurisdictions, you might, depending on where you live, wind up having access to some form of universal representation. In other jurisdictions, you won't have counsel at all. In some jurisdictions, you may be able to get counsel appointed. In other jurisdictions, you simply won't. And so where you are will matter much more than sort of your kind of pure legal status in terms of your potential outcomes. So we're going to see, I think, a lot of local variability in terms of what it means.
Some
to
of us
be-
hope the ACLU will find a way to challenge the position of detention facilities in remote locations that deprive people of access
Counsel.
to their counsel and to family and friends.
Yeah.
Sorry.
No, and the other thing I think is, and this goes to the universal, so in many jurisdictions not many, in a few jurisdictions there is this conversation about universal representation, and we've had some examples of that. And one of the conversations, this is sort of where we see the puzzling disappearance of the criminal justice reform conversation. Right. So on the one hand, we have a criminal justice reform conversation that tells us that the criminal justice system over-criminalizes certain communities, that the labels that are attached to certain people are overdetermined based on the color of their skin and where they live, and so we're very skeptical of those labels. And then we turn around and we start talking about universal representation, and the first thing people start to do is say, well, let's carve out people with criminal convictions. Well, these are the same criminal convictions that we really have high levels of doubt about when it comes to our criminal justice conversations, and I think it's really important to sort of bind those two conversations together when we're talking about universal rep. I know it's not a great political selling point, but I do think this is where sort of having that robust conversation about criminal justice carry over into our conversations about immigration becomes important, and this is particularly true given how expansive the grounds of removability are. So for people who are not immigration people, it's always shocking, I think, for people to learn that lawful permanent residents can be deportable for conduct that was not deportable at the time it was committed, but became deportable by virtue of a change in the law. That's just the way it goes, right? Veterans, people with family members, people who've been here 40 years, those people are deportable, right? If there's deportable, and there's not anything that an immigration judge can do about it in some cases, but in some cases there is relief, and in those cases it seems like access to universal representation shouldn't turn on labels that we think in many contexts are arbitrary, racist, racialized, and having a great deal more to do with class, race, and geography than sort of an individual's character.
That's great. So I have a question, but I do want to actually open it up now and see if other folks want to first start the conversation. So if you have a question, please come to the mic in the middle of the room. We'll all hear you, but whoever ends up watching this on the video feed will not.
Hello, I wanted to start, this is a very practical question, by polling the panel. I work at an institute in Sonoma, California. We have DACA children whom we educate, and we have a lot of DACA and mixed status kids in our community whom we're trying to serve. And I'm not sure, I try to refer them to an actual immigration attorney, which I am not, and I'm never sure exactly what to say when they say, what do I do about DACA? Do I apply? Do I renew? Do I hide? What do I do? Other than giving our boys a hug, like, what can I do, say, or tell them? Thank you.
Well, there's a lot of groups that have various FAQs with, sort of general suggestions on this. I want to say National Immigration Law Center has one. E4FC, Educators for Fair, I forget what it stands for. E4FC also, I think, has something like that. At the end of the day, it's always the individual immigrant's decision. And so in your context, it would obviously be the child's decision in conjunction with their guardian or guardians. But I think the sort of general advice, although others may have heard differently, is if you already are in the system, you should apply for renewal because they already have your information. So if they're still giving out renewals, why not benefit from that? I think there's definitely mixed sort of, there isn't like a total agreement on what to do if you've never gotten DACA before. I think a lot of people feel that it's very risky to apply because the program could end and the government doesn't already have your information. And when you apply, you're revealing often not only your own information, but also private information about family members and other relatives. And in addition, the privacy protections for that information have definitely eroded in the last several months. There have been new lesser privacy guidelines basically issued. And I forget all the exact technical way to talk about it, but basically non-citizen people who are not LPRs, their information, or U.S. citizens, their information is no longer automatically subject to the Federal Privacy Act protections. On the other hand, people may feel differently. People may feel like, look, the administration is still granting DACA applications. It means you can get a work permit. It means, some amount of protection for as long as the program continues. And I think everyone's trying to read the tea leaves. And so far there have been not assurances about its ongoing, nature into the indefinite future, but some suggestions that maybe the administration thinks it's not a bad program and they want to try to work something out.
Let me just add one. I agree with all of that. I'll just add one thing. If the child or young person has had any interaction with law enforcement, I would not have them apply. If it's a new application, because I do think they are vigorously looking. I'm even seeing this in the visa revocation. So there are people just sitting here with visas for random things. I'm not talking about asylum. They're like here as L1 multinational corporation people, and their visas are getting revoked for any law enforcement interaction that's occurring. And I'm not talking about a conviction. I'm talking about an arrest. And so that answer your question. And so my point to you is, if somebody has an arrest, I would not, if they're a new person, I would not have them apply for that. I mean, that's just my personal advice. I'm not giving this to you as like God or anything, but I'm just saying, me, for my child, I would not have a new application for anybody with an arrest on their record. That's me personally.
Another organization in your area that might be outstanding to check with is the Immigrant Legal Resource Center, and particularly, they might even come out and train your staff.
Right.
And give you, they give out red cards about people's rights. There was a wonderful, I can't remember which media outlet covered it, but there was a picture of someone holding their red card out the door in Los Angeles showing, I don't have to talk to you, Mr. Agent. So they will help give you a lot of hands-on information.
I think but the question also highlights the sort of hypocrisy of the administration's statement that DACA is unaffected, ongoing, and continues to be. Right, because we have on the one hand those statements that the program is intact and continues, and on the other hand high-profile arrests of DACA recipients that are meant to cast this very doubt, right, about should I even go forward. And so you have effectively a potential protection that you want people to be able to access, and you want to be able to tell them to access it, and there is this overlay of a shadow of fear that if they do access it, that it puts them in danger. And I think it puts people in a very difficult position, especially when individuals have law enforcement contact of any kind, or something in their record somewhere from some time that suggests they might have some kind of gang affiliation, right, which in California is endemic in some communities. And that makes it really difficult to say, go ahead and apply. And that, I think, is what's so pernicious about the sort of mismatch between the rhetoric about DACA being there and then the realities of the way that that individual DACA recipients are being targeted by the administration. So it makes me nervous.
I have two unrelated questions I'll put out there. One is, I'm a federal government employee. As a federal government employee, I've been told that I'm kind of conflicted, even though I don't deal with immigration, I'm conflicted out from getting involved in a lot of immigration pro bono. Are there suggestions of creative ways to advocate or do pro bono in these regards that you might know about? I know that gets into ethics. And the other question I had is about DAPA, Deferred Action of Parents. I'm trying to recall what happened with that, if that's just totally gone or still in existence.
Do you have any foreign language skills?
Hablo un poquito.
Because sometimes, without getting into the enforcement part of it, helping with citizenship drives, organizations that are helping to help immigrants study for the tests that they need to take to become United States citizens.
I've done some of that,
El
yeah.
poder del voto. Those kinds of things can be very helpful. You could also ask your component for specific ethics permission, depending on what you're planning to do. If it's considered somewhat educational, know your rights presentations, or those kinds of things, you do have to get ethics permission. But I would think that that would be available. But I'm not an expert on how to not break the rules.
Well, I'm for certain you cannot file an appearance in court, obviously, and you can't be an official preparer for an application that's filed. But by the same token, can you help explain things to people? I mean, I don't see why you couldn't help explain. I mean, as long as you're saying I'm not giving legal advice, you know. But if this here is asking for your name, put your name here. I mean, I would feel like that would be a role just any human being could play on that level. But you know, it does get more complicated when you're giving legal advice. So that's
Yeah, I've helped out at immigration
right.
clinics that
Yes.
Casa de Maryland has had, for example.
Right.
Yeah.
Right. Yeah, with your question about DACA was...
Yeah, just,
DAPA,
yeah, I'm
Oh,
trying to remember
DAPA.
what happened with that.
Yeah, nothing.
Okay.
There is no
So
DAPA.
Okay.
so the president announced, it was enjoined, the injunction was upheld, the Supreme Court on a 4-4 vote, basically
Okay,
affirmed without
right.
opinion, the Fifth Circuit, and then we had the change of administration, and so that's where it
Okay.
ends,
Now,
presumably.
there's a twist on it a little bit, though, which is, for the folks who don't know, first of all, what DAPA is. DAPA was the Deferred Action for Parents of Americans and Lawful Residents program. The idea was that based on the effectiveness of DACA, essentially, we were going to provide an opportunity for parents of kids who are LPRs or citizens to come forward affirmatively, and if they pass certain criteria, pass certain background checks, they could get temporary protection from removal and the ability to get work authorization, similar to what DACA offers, but for parents. And didn't take into effect, and it was 4-4 held up by the Supreme Court. But what the court did basically was send it back down to the Texas court, because the Texas court only issued a preliminary injunction in the case. They never issued a final ruling. That case is still sort of hobbling along. It hasn't done anything really, but it also hasn't been thrown out of the courts. And so there is certainly anxiety about the fact that you now have in front of an extraordinarily hostile and entrepreneurial district court judge, two parties in the case basically, other than Maldiv, which did intervene, thankfully. You have Texas and a number of states that are opposed to DAPA, and then you have U.S. government represented by Jeff Sessions, who is as far out there as you can get basically on the anti-immigrant side. And there is concern about whether or not that case, if it's not terminated, could stick around to be used for nefarious purposes, right? So it could be used theoretically to go more broadly into the underlying protection that was provided through DAPA or DACA, which is deferred action, or other sort of exercise of discretion. And it could theoretically still, you could always see an effort to amend the complaint or something to add additional claims. There's a question where, for instance, one of the plaintiff states in that case, Mississippi, previously filed a lawsuit to try and terminate DACA. And that case was thrown out for standing reasons. But that was before the Texas case came out, and a new theory of standing was put forward there. And so if there's the political will to bring those kinds of challenges, there could be a new fight through that. And so that's kind of a sleeping giant. I guess.
Yeah. Thanks for the informative panel, by the way.
Sure.
Yeah.
Good morning, or afternoon, I guess. My name's Sean McCarthy. I'm a semi-retired lawyer. I used to do corporate law, and now I do asylum cases, pro bono. But I have a different question. A lot of people ask me about sanctuary cities, and I know there's been activity in San Francisco. And many, this is an issue in Maryland, in some of the cities and towns I'm familiar with. Can you give me an idea what the status is of the litigation involving sanctuary cities, and can you tell me whether the anti-commandeering statute or decisions of the Supreme Court are in play?
Who wants to do it? Okay, well, I'll do it then, that's fine. There is an injunction currently pending or in existence against President Trump's very broad order, and that injunction was issued by my predecessor at the Department of Justice, Bill Orrick, is the guy I replaced. Now he's a federal judge in San Francisco, and what he did was he enjoined the sort of broad, the broad executive order, because that executive order could have been interpreted to say you lose all of your federal funding if you are in violation of some unspecified commands that the federal government is giving you with regard to immigration. And so Judge Orrick said that even though the Department of Justice hadn't done anything yet in terms of removing funding, the threat of uncertainty for budgeting purposes for towns like San Francisco were too high. And so now the federal government's asked for reconsideration of this, and they will appeal, presumably, on, I think most importantly for them are these rightness and standing grounds, to the extent that they're saying that, look, nothing's actually been done. We've now given a narrower definition, which a lot of the cities are very comfortable with, because very few cities, if any, say that they openly and willingly violate the statute, which is 8 U.S.C. 1373, which says that you can't have a prohibition on giving information, immigration information that is requested. Almost no cities, I don't know if you guys know of any cities who actually say, I am flagrantly in violation of 8 U.S.C. 1373. I don't think there are any. And so from that standpoint, I think it will be interesting to see if the Ninth Circuit actually wants to continue with this litigation in a world where the Department of Justice is making the representation to a court of law that they're not going to go after anyone who is in willful violation of 8 U.S.C. 1373. But
I think this is another, I mean, like the travel ban, this is another case where we see the mismatch between the sort of legal, in the four corners, legal definitions that the administration deploys, and then the language that they use about concepts. And so they define it is in the January 25th Interior Enforcement Order, where they define sanctuary cities as jurisdictions that violate 8 U.S.C. Section 1373. To which everyone says, why would we violate federal law? Like that's just asking for trouble. But the precatory language of that same order speaks very broadly about jurisdictions that don't cooperate. And then there were statements made, particularly by Sessions, about the ability of the administration to claw back existing federal funding streams that were given to these jurisdictions that don't play ball with the federal government. And so it was this broad rhetorical stance that clearly runs afoul of the anti-commandeering principles, right? You're saying, if you don't do what we tell you to do, we'll take away all your money, right? That just, we know that's unconstitutional. But the kind of narrow legal language is, of course, more careful, right? They're saying if you violate federal law, and so courts are struggling with what do we believe? Do we believe sort of the narrow definition here, or do we believe everything that you're saying about what you plan to do with this law, in much the same way that we see them struggling with those concepts in the travel ban?
The only update I'll give to that, though, is it was interesting, actually. So the court basically defanged it by issuing an order that essentially said, we're going to hold you to what you said in court, basically, which is it's an extremely narrow order, actually. They then put out a statement essentially saying, look, our new policy is consistent with that, extremely narrow. And it looked like basically sort of a waving the white flag on the issue. The next day, the president delivered his proposed budget to Congress. And the proposed budget in some appendix and a very far off part of the budget contains proposed new language they want to have adopted that would create expansive new authority to tie federal funding to sanctuary policies and other things. And so I think in some ways that itself is a signal, one, that we'll see the fight again in Congress. We've seen it before. But two, that again, they recognize that there is additional legislative change that's needed to do what they want to have done.
Thank you very much.
Sure. Yes.
Hi, I'm with Demos, and regarding sanctuary cities, we on Latino Justice put out a report that has a lot of this information that I wanted to answer the gentleman's question. But I also was thinking about, just how horrible and terrible federal immigration law and the constitutional standards around it have become. Like, that seems to be the main theme of the panel, right? We're talking about fundamental due process rights. I'm very concerned about equal protection rights, and really appreciated Professor Chacón's talk about the discussion or the intersection between and the mismatch between how we talk about policing and racial profiling and mass incarceration and immigration. It's almost as if, And the decisions show us, the Supreme Court decisions, there's just like hardly any chance to have, equal protection in the field of federal immigration. And I know you all are fighting for that. And there's just one other thing I want to connect with it too. So I'm very concerned that the definition of the border has expanded, right? My colleague from the ACLU was talking about expedited removal being expanded across the country. And so that also means that very bad decisions about racial profiling, like the Brignoni-Ponce case, that say it's okay if Border Patrol racially profile close to the border, could explode across the country. And we know it's already exploded across the country. So my question is sort of a dual question, if you can take all that into account. But, do we have any hope of protecting the right to freedom from racial profiling by ICE and immigration enforcement? And also, is there not some fertile ground to develop that in these detainer cases? So the basis of sanctuary, I think, is that local police and local officials do not have jurisdiction to enforce federal immigration law. And so, we may be able to try to hold the local police who are still, as far as I can tell, passing along people to ICE, and the majority of people who are sent along to ICE or find themselves in ICE custody, it's still about 50% through local police. Maybe that's a way of developing some of these protections that would have a real impact in people's lives. I'm kind of stuck on how we could possibly enforce equal protection in this arena, and would like to.
I have a crazy equal protection claim. So feel free to get excited about this one. Okay. This is one that nobody talks about. I don't even know if you could win, but you guys file a lot of lawsuits and you win surprisingly very many. So okay. I'll give you. So we can't deport people to China. China tells us, they give us the middle finger. They say we won't let you do it. So we just can't unless we have like a military activity to go deport someone to China. You can't do it for the most part. I mean, we do like 800 a year. But so anyway, the point of this is to say that what we end up doing is then we don't target any immigration enforcement resources toward Chinese nationals, which is a large segment of undocumented individuals, and we actually target it all toward people from countries that cooperate, the biggest cooperator being Mexico, because they have to cooperate because there's so many interests that are at stake in the Mexican-U.S. bilateral relationship. But it'd be interesting if someone were to look at, my God, why is ICE spending 95% of its immigration resources targeting Mexican nationals and none targeting Chinese? And is there a racial component to this? And granted, I don't know if a court would be satisfied with a defense with, well, we can't deport people to China, so why bother? If you're actually not you're like literally targeting people. So that's just one that popped to my head recently that I thought was a fascinating one. But I do think, you've seen equal protection type claims in the travel ban case to the extent that it's possible. Where it gets complicated, though, is that the immigration law is meant to pick winners and losers. That's almost the point of immigration law. So, for instance, if you say we have a 5,000 visa program with Chile, that's what you're doing. You're creating a 5,000 visa program with Chile, or we have a refugee program that's going to pick 20,000 people from X country. You're doing that. That's sort of the point of immigration law. And so that's where it gets complicated in the equal protection realm, is how do you distinguish legitimate discrimination, in a sense, from illegitimate discrimination?
And as a trial court judge who has to go case by case, right, because nothing I do is precedential, part of it is educating your colleagues on motions to suppress. If it is egregious, the tradition in immigration law from time immemorial when I was in private practice was not to contest alienage and removability, but maybe that's something that people will have to do more, and again, that means they need lawyers. I can't see someone pro se showing it's an egregious violation of the Fourth or Fifth Amendment, which is what needs to be shown, but you can do a motion to suppress in immigration law if you think someone's been racially profiled.
I mean, really quickly on the border, it is true as an effective matter that expanding expedited removal all over the place and also just, working more with local enforcement means that it feels like the border is expanding elsewhere. But as a legal matter, I'd like to see them try to say, you know, like, the middle of the country is the border from a Fourth Amendment perspective. I don't think that those cases can be imported in that way, and the cases are, you know, very tied to the special circumstances of the border. And a lot of those cases, if you apply the reasoning to, you know, other places that are, you know, very mixed populations, huge, you know, proportions of U.S. citizens and lawful non-citizens, the sort of enforcement practices that they condone near the border are not ones that then make sense in the middle of the country. So, I mean, that's a quick squib on that.
Yeah, I guess the only other thing I'd add is I think we lawyers can be more aggressive about making sure that in the street policing context, i.e. where a local police officer or a local ICE agent is making a call on the basis of appearance, right, which we know to be okay, and, you know, to a certain extent in the border context, Brignoni Ponce, but where you have local police officers making a call and they're making a call based on appearance, it seems to me they're making national origin judgments, right? They can't be making nationality judgments because they don't know your nationality by looking at you, right? They are making national origin determinations. And there are courts that are conflating national origin and nationality. Those are not the same thing. And I think it's really important for lawyers to be vigilant about policing that line. I mean, I frankly think it's impossible to do street policing of immigration without racial profiling, and I think that's why street policing of immigration is problematic, right? But I think stepping away from that, it is really important to recognize that there are protections against national origin profiling in general policing contexts that are not undermined by the fact that immigration makes nationality-based distinctions, and it's important to sort of stick to those.
Thank you.
Well, so we are actually out of time. I want to thank the panelists, obviously, for taking the time and for the interesting conversation, to all of you, obviously, for engaging and asking good questions. Just so you know, for what's happening next, there is a lunch featuring an address by Senator Mazie Hirono, and that's beginning immediately after this in the presidential ballroom, and volunteers are on site to help direct you there. So please give it up for the panelists.